Hello again, folks. Let's continue our discussion on the Delhi Laws Act case. We have looked at the agenda in the previous video, and we have discussed the first item on that agenda in that video: constitutional doctrines involved over here, separation of powers, and the doctrine of checks and balances. This video will be devoted to Article 143, what it entails, why does it exist, and so on. And in the next one, we will look at what delegated legislation is as a concept, and then finally we will move on to the actual judgment of the Supreme Court in the matter of the Delhi Laws Act. So first of all, in this video, Article 143 is the point that we will be looking at. Since this is the first time this particular article was invoked by the President of India, therefore we should, I feel, spend a few minutes on talking about what this article entails. Article 143 is entitled Advisory Jurisdiction of the Supreme Court, not its original jurisdiction, not its appellate jurisdiction, not its extraordinary jurisdiction, but its advisory jurisdiction, wherein the President may seek the opinion of the Supreme Court on any question of law or fact, on a question of public importance. The question needs to be of public importance as per the judgment of the President, who of course will act on the aid and advice of his Council of Ministers led by the Prime Minister. So a lot of things in the background. Let's look at the actual article. If at any time it appears to the President that a question of law or fact has arisen or is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain the opinion of the Supreme Court upon it, he may refer the question to the court for consideration, and the court may, after such hearing as it thinks fit, report to the President its opinion thereon. The court may report to the President on its opinion. 143.2 is not our concern right now. We will perhaps look at it down the line. This report that the Supreme Court may decide to give, if the President has asked, the court can, that is, refuse. But if it does indeed accept the President's request, it shall give this report in an open court like any other opinion that it gives. That is Article 145 clause 4. So that is 143 in short, that the President can seek the opinion, the advice of the Supreme Court on any matter that he thinks fit, a matter of law or a matter of fact, provided that the matter in the President's judgment is of public importance. Now, we often look at constitutional provisions and their origins, that because our constitution was so late in the day compared to some other democracies, compared to most other pre-World War democracies, it is often seen that we have borrowed some provisions from some constitution or the other, or some enactment or the other. Advisory jurisdiction, akin to that seen in Article 143, is also seen in Section 4 of the Judicial Committee Act of 1833, which basically ensures that the Privy Council will provide its advice to the Crown of the United Kingdom, to the Queen currently, on any matter that she refers to it. Section 60 of the Canadian Supreme Court Act of 1906 is another example of this advisory jurisdiction, and in fact Section 60 of the Canadian Supreme Court Act is invoked extensively. It is in fact the preferred means of resolving constitutional questions in Canada. So any of you who are looking to practice over there or are already involved in Canadian jurisprudence will be very familiar with this provision, Section 60 of the Canadian Supreme Court Act of 1906. But our direct origin of Article 143 comes from Section 213 of the Government of India Act 1935. The Government of India Act 1935, the longest legislation ever enacted by the British Parliament, refers to the advisory jurisdiction in Section 213, the power of the Governor General to consult the Federal Court. Clause 1 is very similar to Clause 1 of Article 143, the only difference being that the Governor General could only refer to the federal court a question of law, not a question of fact, which the President of India can do, along with a question of law as well. And of course, the federal court has been succeeded by the Supreme Court. The Governor General has been succeeded by the President. Article 143 has been invoked a few times, not extensively, just over a dozen times. The first was, of course, this case, which we will look at in detail. And the other occasions were 1958 Kerala Education Bill, then the Berubari Union, which we will look at in a separate discussion on our channel, the Sea Customs Act, the immunities of state legislatures question, the presidential pool question of 1974, the special courts matter of 1978. This was a very interesting opinion where the Supreme Court almost refused to give any advice because the situation appeared to be quite hypothetical. This was the matter related to creating special courts to hear of crimes committed during the recently lifted emergency. The Kaveri Water Disputes Tribunal matter of 1991 is another one which we will look at later on. The 1993 Ram Janmabhoomi dispute referral under Article 143 is an interesting one because over here in this case, the Supreme Court refused to give any advice, refused to give any opinion on the question presented to it by the President. This is the one occasion where the Supreme Court has refused to give a report, which kind of underlines for us this particular word in Article 143. The court may report to the President its opinion thereon. The court is not forced to or compelled to give its opinion. It doesn't say the court shall give its opinion, but the court may. And in that particular case, 1993 Ram Janmabhoomi dispute referral, the Supreme Court refused to give any opinion. The others are also quite interesting, the ones that still remain in our exhaustive list of 13 invocations of Article 143. The 2004 referral on the Gujarat natural gas concern, that is another one which we will look at. This was a question of whether natural gas can be legislated upon by the Parliament exclusively as per the Union list or by the state legislatures exclusively as per the state list. Quite a few interesting things under discussion. The 2016 Punjab Termination of Agreement Act deals with the Satluj Yamuna Canal and the termination of agreement between Punjab and Haryana and those states regarding the sharing of those 5 rivers that give Punjab its name. So quite a few political questions have reached the Supreme Court via Article 143, but the court has dealt with almost all of them except for that one exception in the Ram Janmabhoomi dispute. But it will give us another indication of the difference between these Westminster democracies, these British Dominion democracies, former or current dominions. We saw that Article 143 owes its origins to the 1833 enactment in UK, the 1906 enactment in Canada, and the 1935 enactment for British India. But there was no reference to any American provision which is similar to this one. There is no advisory jurisdiction available in the United States, although a couple of times it has been attempted, but on all those occasions the Supreme Court has refused to give advisory opinions, saying that that is not part of its jurisdiction, precisely for this reason that it will then encroach upon political or legislative or administrative matters, and separation of powers in the United States is very strict. So the Supreme Court in the United States does not have this advisory jurisdiction, but our court does, and it was invoked for the first time in this particular case that we are currently discussing, the matter of the Delhi Laws Act. And the need was felt for an advisory opinion of the Supreme Court precisely because the extent of the separation of powers in India was under discussion. It was quite evident that separation of powers is not strict in India. For example, the executive is, for all practical purposes, a subset of the legislature. It's not just a functional overlap between the three wings, but also personnel overlap. As you are no doubt aware, for a person to be appointed as a minister in the Council of Ministers of a state legislature or of the union, that person already has to be a member of that state legislature or of the parliament, either Lok Sabha or Rajya Sabha, or in the case of the states, either the Vidhan Sabha or the Vidhan Parishad. And if that person is appointed a minister without being a member of the legislature, then that person should be elected to the legislature within 6 months of that person's appointment as a minister. So you actually have to be a part of the legislature in order to be part of the executive, of the high executive in India. So this overlap existed, but it needed to be clarified exactly what is allowed and what is not allowed, what is permitted and what is not, and that dealt with delegated legislation as well, or what is also known as subordinate legislation. We will look at that in the next video. What is the extent of delegation? What all can the legislature delegate to an executive body? Can it delegate simply everything next time? Right? There should be some limitations, something that continues to follow the constitutional doctrine and does not go beyond it, is not ultra vires the constitution. So what exactly is this demarcation? Where is the line drawn? What is the extent of delegation that should be permitted in the Indian constitutional scheme was the concern that was felt, and that is why the President of India felt the need to invoke Article 143 in the matter of the Delhi Laws Act, decided on 23rd May 1951, a judgment which we will eventually look at. But that's it for the moment on this very short introduction to Article 143. Hope you like it. See you again next time. Bye-bye.